We will call this Titusville Code Board meeting into order. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purposes may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be heard, or to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the Board at the time their case or agenda items comes before the Board for hearing. Any person found to be in violation of the City of Titusville's Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please, and I got to do it myself. Please silence your cell phones. And I guess I get the dubious honor of swearing in the staff. Staff, please raise your right hands. Do you swear or affirm the testimony you provide to the Board will be the truth, the whole truth, and nothing but the truth? Thank you. All right. I need approval of minutes of last month, please.
So moved.
There was something I think was left out of the minutes.
Okay.
When we were talking about the agenda and the minutes, there was a discussion that you're trying to go paperless, and that in the future probably there will be laptops at each of these stations. I think it's important to put that in the minutes, considering the atmosphere here now with the Code Enforcement Board.
So when did that come up? When did that come up?
It came up when we were discussing the minutes and the agenda.
I'm not sure, but I think you may have been absent that day.
I was not here because I had surgery. So
The meeting had already been called to order, and it was part of the discussion. I think it should be reflected in the minutes.
Megan, can you reflect that in the minutes? All right. Any other corrections? All right. Now, who wants to approve them with that?
I'll make a motion to approve them as amended by Gina.
Okay.
I second.
All right. Motion made by Joe, second by
Ashley.
Ashley. Any questions? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes. Motion moved. All right. All right, Miss Chelsea, you're on top.
Good afternoon.
Good afternoon.
I'd like to wish a belated Happy Mother's Day to all the mothers in the room. I hope you all had a nice weekend. The first case listed on your agenda under old business is number 1825 for the property located at 201 Robbins Avenue. This case has been found in compliance as of April 27th, 2018, and as this case was previously continued, the city wishes to close this matter.
You need a motion on that?
For cases that have not previously been heard but have been continued by this board, I will need to hear a motion that you can close this in accordance with the suggestion made by me.
Okay.
So moved.
Second.
Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Motion carried. All right. Next case.
The next case is number 18-29 for the property located at 41-7 70 Barnett Avenue. Again, this case was previously continued by this board, and this case has been found in compliance as the BTR has been obtained for the property as of May 1st, 2018. And again, the city wishes to close this case.
So moved.
Second?
Second.
Any questions? Roll call vote, please.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Motion carried. Okay.
Okay, thank you. The next case is number 18-36 for the property located at 500 Titus Street. This case was previously found in violation by the Code Enforcement Board, and the board ordered the respondent to correct the violations by April 9th, 2018. The city had hired the contractor and ordered the contractor to go out and cut the property, so this property was found in compliance as of April 21st, 2018, which is 12 days after the order to correct date. So this board has the ability to assess a fine or not, depending on your decision on this case. Fines were previously the costs were previously assessed in the amount of $340.44. I have Officer Hutchings here to provide testimony regarding that the property is in compliance.
So it's in compliance because the city cut the grass?
That's correct.
Okay.
The costs have been sent to the property owner regarding the invoice for the contractor having cut that property, although to my knowledge that charge has not been paid, and neither has the cost assessed against the property for this case.
Is the charge $340.44?
That is the cost for presenting this case before the board. That's not
Okay.
the same as the...
That does not include the cost of the mowing?
Correct.
Okay. That's the city cost of the beginning.
Correct.
All right. What does the board want to do?
The city should be reimbursed for the costs, I think, definitely.
Okay, but...
And whatever money that they
So-
paid out.
So put it in the motion.
Just to clarify, so the board understands, the costs that were assessed, the $340,
Right.
were assessed previously at the last board meeting that you heard this case. And if the decision for you all to decide is whether or not you think that 12 days should be assessed a daily fine in addition to the costs that you've previously assessed. Separate and apart from what you decide today, there's a charge associated with the contractor cutting it that's not on your agenda today. I'm just informing you that that is a part of the property owner's responsibility that has not been met yet.
Thank you.
I think that the $340 would be sufficient. Why
That's the $340 that was...
That was assessed.
No, it was not assessed. That was accrued by the city.
No, he was correct. It
No,
was assessed.
By the city prior to the grass mowing.
I wouldn't mind imposing a daily fine for the 12 days. That they left 12
Yep.
days.
Microphone, please.
They left 12 days that they weren't in compliance, and I wouldn't mind doing a fine for those as well.
And remember, they did not come into compliance till the city brought it into compliance, not them.
Oh, I thought they brought it in, I'm sorry.
And that
Okay,
bill is
yes.
still
I
unpaid as
agree with
well.
you then.
Okay.
I
All
agree
right,
with
go
Ashley.
ahead.
Okay, I move that the board issue the following findings of facts in case number 18-36 relating to the defendant M&T Bank. The defendant continued to be in violation of the following sections of the Code of Ordinances of the City of Titusville on April the 20th, 2018.
It was in compliance on the 21st.
So I can use the 21st on that date.
Yes.
Yes? Okay, the 21st, 2018. Section 13-26, by reason of overgrowth.
Second?
Okay.
Gina. Any questions? Roll call vote, please.
Vice Chairman Beckles?
Yes.
Member Edens?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its final judgment assessing fine and imposing lien relating to the defendant M&T Bank based upon the findings of fact issued this date, and the judgment contains the following provisions. The defendant is assessed in order to pay a fine of $100 per day for the violation of Section 13-26 and the cost reserved for the City of Titusville. the fine shall commence on,
The costs were previously assessed.
okay, so that doesn't need to be addressed. The fine should commence today?
The final judgment should include a reference to the costs previously assessed.
Okay,
Commence on the 9th, on the day it was supposed to be.
okay.
Yeah, should do, yeah.
All right, so the fine shall commence on April the 9th, 2018, and shall continue until the code violations have been corrected to the written satisfaction of the code enforcement officer.
Continue until the 21st.
Yeah, this could be done.
Correct. The board attorney should craft the final judgment to say that they continue and stop on the 21st as of the date of the notice of compliance.
Okay.
Second?
Okay.
No, I can't say.
Second.
Okay, roll call, any discussion? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Chairman Bell?
Yes, motion carried. Next case, please.
The next case on your agenda is number 18-53 for the property located at 2408 Fox Hollow Drive. This case was previously continued by this board, and the owner has achieved compliance as of April 18th, 2018 by obtaining the necessary business tax receipt. As of this date, the city wishes to close this case because of compliance.
So moved?
Second.
Okay. Any discussion? Roll call vote, please.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Vice Chairman Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes, motion carried. All right.
Next, case number 18-59 is relating to the property located at 3478 South Hopkins Avenue. Again, this case was previously continued by this board and later achieved compliance on April 12th, 2018 by obtaining the necessary business tax receipt. And as such, the city wishes to close this case due to compliance.
So moved.
Second?
All right, who so moved it first?
I did.
This is, okay.
Ozark?
Second by Ashley.
Yes.
Any discussion? Any discussion? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes, motion carried.
The next case and last case under old business is number 18-64 for the property located at 1015 North Carpenter Road. This case was previously continued to allow the owner time to achieve compliance, which the officer has identified compliance was achieved on May 4th, 2018. And as such, the city wishes to withdraw this, to close this case due to compliance.
You said May 4th?
Yes. The case was previously continued until today, but the case did achieve compliance on May 4th. It's not printed in your agenda.
So moved.
Second?
So moved.
Motion made by Ariel, a second by Ashley.
Yes.
Any questions? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes, motion carried. New business, I suppose.
Yes, ma'am. The first case listed is number 18-71 for the property located at 1640 Gulfview Drive. I have a couple of different staff members here to provide testimony. I have both Officer Lewis and the building department has Paul Bellington here to provide testimony regarding the building permit details that were submitted regarding to the violation of 6-56 permit required. I'd like to invite Officer Lewis up first to present the notices to the board. Okay, Officer Lewis, did you have an opportunity to inspect the premises at 1640 Gulfview Drive?
Yes, I did.
And when was your initial inspection? Okay. I'll retract that question. The nature of the violation here that's before this board, as I described just a moment ago, a 656 permit required. The building department has turned this case over to the code enforcement department for the purpose of posting and getting the process through the Chapter 162 requirements for noticing the property owner that this case is subject to the code enforcement board action, which is why Officer Lewis is here to give testimony regarding the notices that were provided to the owner of record. I have the first item that we have in the record is a notice of violation that was prepared by the Code Enforcement Board Secretary, that she has sworn that the notice of violation was attempted by certified mail, and the city is also providing the tracking number showing that the certified mail was submitted to the property owner regarding the initial notice of violation, which does comply with Florida statutes for the initial notice of violation. I'd like to submit this to the board for your review as exhibit number 1.
Chairman Bell? Chairman Bell?
At the end of the line, please. And so subsequent to the initial notice of violation that was submitted, the Code Enforcement Board Secretary and Department also submitted the notice of hearing and complaint that was also posted on the property. And I have Officer Lewis here who did inspect the property and post the property for the purpose of proceeding with this case forward. Officer Lewis, do you have the proof of mailing and affidavit attesting to the notice?
I do.
And can you please submit the proof of mailing and affidavit as to the notice of hearing and complaint into the record as exhibit number 2? I can also add to the facts of this case that I am certain that the owner has received notice of this case because I received a letter of complaint from the owner disputing the fact that he did not believe that a permit was required for several other issues. I won't comment exactly on what his arguments are. I expected that he would be here present today because of the contents of his message to the council member and city manager that has gotten involved in this case, and I do not see him in the audience today. But I do know, based on this personal knowledge of the responses with the owner, that he does know about this hearing today, as stated by him in his email that I've received. I have Paul from the building department that I'd like to invite up to give you a little bit more of the background on this case because it's been going on for some time. It's not something that just evolved. It was turned over from the building department into the code enforcement department. So, Officer Lewis, if you'll take a seat, please. I'll come back to you later. Thank you. Paul, can you tell the Code Enforcement Board when the initial application was submitted by the property owner for a permit to alter his property in accordance with the request to build a carport on his property?
Yes, ma'am. The application was initially turned in July 23rd, 2015. Went through the review route. It appears that it finished the review route on July 25th, 2015, so 2 days later. The application was, we needed more information from the applicant. This is what he submitted. Is this on? Can I put this on?
It is on. Yeah, the overhead will show a survey that was submitted with the initial application by the owner of the property. I'd like to also add that Mr. Stephen Wayne purchased the property on July 1st, 2015, and then submitted an application to the city 3 weeks later when he became the owner of this property for this particular permit to add the carport onto the existing structure.
So as you can see here, he submitted this survey, which is really all you need for something like this. It's pretty simple. But he had no dimension on how far the carport would be from his front property line. And that is the issue here.
I'm sorry, did you say he does or does not have that dimension?
He does not have that dimension.
What dimension is that he's missing?
This dimension here from the front property line to the carport.
And what do you call that in the building department?
That's the front setback. Is
Okay.
this whole area. I mean, every lot in town has an area called, their front setback. They can't have anything in that front setback. And in his case, he has a 25-foot front setback. And from what I've seen, he's in his front setback with this building. So he could have it, but he'd have to meet that 25-foot front setback. But that's why they kicked it back, because he didn't put any dimension there, and then he went ahead and put it up without a permit. And
Would you like to show the photos of the property before and after?
Yeah.
I have a question on that.
Can you put your microphone on?
I'm sorry.
That's okay.
I had a question on it. From the property line to the frontage of the house, is there a dimension there?
no, there's not on this survey.
Okay. They're not settled up, because I'd say he's got the dimension of, from the house to, the dimension, I think, from the house to the carport, but he doesn't have it from the carport to the line, and he has a total dimension of the property, of the carport that he's, and it'd be just a,
Yes, sir. I see what you're saying. I mean, I could add up the dimensions. It might not be completely accurate, but we could get a good
would
idea.
be within an inch or so, though.
Well, probably, yes, sir. And typically those older neighborhoods, the front of the house is right there on that front setback line. So you already know you can't build anything past that.
Paul, what's the date of the photograph that you have on display?
January 25th, 2015.
So this is prior to the owner taking ownership of this particular property.
So this is not the carport he built?
This is the pre-existing carport.
Okay.
So go ahead and show them what happened after the alteration was made.
It's kind of hard to see.
Other direction, maybe. Okay, so basically, there's an additional carport
Oh, so
added
it's-
on
okay.
in front of
Does-
the existing carport. The one that's white is what was added in front of the pre-existing carport.
So the white spot is not the driveway, that's
That's the carport.
That's a carport.
And we can pass these two pictures down the line for,
What date was that structure erected?
January 12th is
The
the
date-
date on this picture. I don't know exactly when it was done.
the property appraiser does aerial photographs in January for each property. And so the property appraiser has provided the photographs in January of each year. And so we went and looked at 6 months after he took ownership, about 6 months after he submitted the application to the city, which was denied. January 2016 shows the added carport that you see before you on the overhead.
Is that a permanent structure, or is that one of those with the canvas tops? I can't really tell.
No, that's a permanent one. This is the aluminum, like Carolina
Okay.
carport.
I'm bad eyes,
Yeah,
man.
no, it's
can't tell from the picture. Okay.
okay. Yeah.
And it's been 2 years since then, more than 2 years since then.
3 years now.
Yep.
Well, since they saw the structure was erected.
We can find those photos online today. I don't know when they were added or when the city became aware that the carport was actually added. What we know is that the application was submitted by the owner in July of 2015, and the review was denied, and thereafter the applicant did not continue to pursue further discussion with the city. And yes, time has passed since it was put up, but that doesn't allow an unpermitted structure to remain in place without a permit that should be in place for it, especially when it's in the front yard setback where it could not be permitted to exist in.
So the letter he sent to you is after he got something from the code board
Correct.
about
Bringing it to the code
being
board
in-
to
not being in
correct.
compliance where he's at now.
Correct.
Okay.
So compliance would require him to take down this structure.
To get a permit, and the permit may not be able to be issued, that's in the building department's purview of making the determination of whether a permit can be issued. Your issue today, your question is whether or not a permit was issued for the alterations to the property after the owner took possession in July 2015. You can see from the photographs that a carport was added. You can hear from the testimony of the building department that a permit was applied for but not obtained. It was denied. There was no further discussion between the owner and the city to
None
allow
at
that.
all?
There's none to
None
our
at all.
knowledge, and we don't know whether he may have had conversations with folks that's not written into the file. That is always possible, but I don't have anyone here today that's telling me otherwise.
His plans didn't delineate the dimension, but his
can put it
original
back.
plan did go past the 25-foot setback? Or there was just a question because he didn't write it in himself?
And typically, they'll just put it on there, you know, that way there's no question. That way I don't have to add up the numbers and make that determination myself, but, I mean, I can do it real quick if you want. I didn't do the review. That was done in 2015. Somebody else did it. But it appears, I mean, it's pretty clear. It's in the front setback, so.
I've submitted into evidence the survey that was submitted by the owner of the property regarding the permit application from 2015, which shows his drawings and sketch of the dimensions. You should be able to see that in a moment.
But this is the original, right?
No, that's the original.
Yes, right
That's
here.
That's the original.
Oh, yeah, okay.
And there are no costs for the city yet because it hasn't been officially a code enforcement
This
case.
is new business, so it's your first time to decide whether or not you think there is a finding of fact, that there is in fact a violation, which is what I'm asking you to find today, that no permit has been obtained for the additions to this property. And as such, the finding of fact would show that he has, or the owner has, a set period of time to come into compliance, and you guys determine how long that is. And after typically it was 1 month, you usually give about that time for the owner to come into compliance or say why they haven't done so, then they would be assessed next month. That
If,
amount.
sorry, excuse me, I didn't mean to interrupt.
It's okay.
If this was a structure with the canvas, as I mentioned before, would a permit still be required?
Yes, sir.
Okay, thank you.
And furthermore, just to add to it, I've seen the pictures, like, you know, the close-up pictures of it. It's not attached to the house, so technically it's an accessory structure, which can't be in the front yard at all. So he would also have to submit some type of detail on how he was going to attach it to the front of
So
the house.
it's not attached to the first carport at all?
No, it's not, no.
And nobody knows whether he was made aware of the 25-foot setback when he originally,
He was made aware. I mean, I can look back in the review routes and see the comments, and we don't ever just make comments and not contact the applicant. Whether it was more than likely it was a phone call, so it wasn't documented.
so literally it was just a matter of adding 13 and a half feet long and 12 feet long on the carport.
No,
No,
the document is what it was submitted to by the owner, is that correct?
Yes, ma'am.
Well, but this was rejected because it was incomplete, and he actually did write, is this his notation?
Yes, ma'am. That's the
So
applicant.
he wrote the length of the structure, and it's documented here that the carport's 12 feet, so it was just one math equation.
Okay. Yeah, and one reviewer made the comment that, you know, no front setback dimension. He hasn't put any dimension on there. Another one put, you know, appears to be in the front setback. So that equation was done. I mean, they did that addition.
And regardless of whether that equation was done or not, the owner didn't complete a final inspection of the permit application and complete the requirements to obtain the permit, which is the violation that I'm asking you about today.
Okay. This will be the
There's
first reading.
one additional piece of evidence that I'd like to have submitted to the record. Paul, I can have you sit down. Thank you for your help. I didn't have Frank Lewis submit the cost recovery statement.
That's what I was asking about, was cost recovery.
Officer Lewis, do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
I do.
And what is the amount?
$340.44.
Please submit the cost recovery statement into evidence. Does the board have any other questions of staff?
Oh, did you talk to him at all, Mr. Lewis?
When you posted the property, did you speak to the owner?
No, there was nobody, no, I spoke to nobody the day I posted it.
Okay.
Thank you.
All right. What do y'all want to do? It's the first reading.
I got it.
You doing it, Ed?
Yeah, I'm going
Okay.
to take it. I was just reviewing here. I move that the board issue the following finding of the fact in case number 18-71 relating to the defendant Stephen Wayne and Jessica Wayne. The defendant can, let me see, oh wait, I'm on the wrong page. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner or in possession of the real property located at 1640 Goldview Drive, Titusville, Florida.
Go for you.
Golfview.
Please?
Golfview Drive. Golf, as in.
Oh, I'm sorry. Golfview Drive, Titusville, Florida. The defendant is in violation of the following provisions of the Code Enforcement Ordinance of the City of Titusville. Section 6-56, permit required.
Second. Oh.
Motion by Ed, second by Gina. Any questions? Roll call vote, please.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, please.
I move that the board issue its order to correct relating to the defendant, Stephen Wayne and Jessica Wayne, judging the defendant to be in violation of the section of Code of Ordinance of the City of Titusville as determined in the finding of the fact, giving the defendant until
June 8th. If you're doing 1 month, that's the Friday before our next board meeting is June 8th. If that's what our strategy is going to be, or the Fridays before.
Okay, he had not even gotten to the date yet.
Oh, I know. I figured he probably hadn't done the math
Okay,
yet.
all right, go ahead. Let him finish
Don't
out.
confuse me more than what I already am.
All right, just,
Given the defendant until, are we using the 9 a.m.?
yes, still using 9 a.m.
Yes, okay. 9 a.m. noon on June the 8th, 2018, to correct the violation to written satisfaction of the code enforcement officers or to appear before the board at the City Hall of Titusville on June the 11th, 2018, to show cause why the violation has not been corrected and why this board should proceed to impose fines for the violation. The defendant is ordered to pay $340.44, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second.
Second by RL.
Second.
Okay. Motion by Ed, second by RL. Any discussion? Roll call vote, please.
Vice Chairman Beckles?
Yes.
Member Edens?
Yes.
Member Moniz?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. All right, next case, please.
Thank you. Next case on your agenda is 18-72 for the property located at 206 Willow Street. I'd like to invite Officer Crisco here to provide his testimony regarding this case. Bob, did you have an opportunity to inspect the premises at 206 Willow Street?
Yes, I did.
When was your first inspection?
November 11, 2018.
November 11th,
2018, we're not there yet. How about 2017?
Yeah, that's, wow. Why is that showing 2018?
It's
No,
January.
I'm sorry, January.
So it's January the
Yeah,
11th?
January 11th, 2018.
All right,
Yeah, that's better.
we got it.
Sorry. What did I say?
You said November.
Yeah.
Wishful thinking.
Oh, because of the 111.
Yeah.
Okay. All right, we're good.
Thank you. And did you find this property in violation of the Titusville Code of Ordinances?
Yes.
What's the nature of the violation?
Section 1223, junk and debris.
Did you provide notice to the owner of a record by first class and certified mail as well as posting the same on the property?
Yes.
And do you have a affidavit attesting to this notice?
Yes.
Please submit the affidavit into evidence as exhibit number 1.
They all left you. They all left you.
I'm still here with you, it's okay.
Thank you.
You're welcome. Did you reinspect the premises after January 11th to determine if the property was in compliance with the violations as originally cited?
Yes, on January 29th.
Yeah.
2018.
And was the property still in violation?
Yes, it was.
Did you issue a complaint?
Yes.
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail posting the same on the property and at City Hall?
Yes, I did.
Please, do you have an affidavit as to this notice?
Yes.
Please submit the affidavit into evidence as exhibit number 2. Officer Crisco, did you take any photographs of 206 Willow Street?
Yes, this morning when it was still in violation.
Okay, so you've taken a couple photographs. Would you like to display them on the overhead?
Yes.
Show us what it looks like. This violation of junk and debris. Oh, we need to zoom out a little bit.
Oh, yeah, that looks good.
Yeah, I can see it.
That's towards the front of the backyard. This is in the middle.
Holy moly.
You see it?
It's a little too bright.
Yeah, that looks good.
So this is one of the photographs. Let's show the other one. That is the first one you saw.
And one more. And that's the bulk of,
Birdhouse looks nice.
All right, I'm going to submit these photos into evidence as exhibit number 3.
Does anybody live in there, Bob?
Bob, is anyone living at the property?
yes.
And can you just state for the record the date of the photographs? Was that you took those?
Those were this morning.
Okay, thank you.
Is that the backyard?
Yes.
Is there any history to the junk and debris of this property?
I
As far as the junk and debris, where has it been located or relocated?
don't remember, sorry.
Okay, no worries. Do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes,
And what is the amount?
$463.71.
Please submit the cost recovery statement into evidence as exhibit number 4. Officer Crisco, do you have anything else to add?
Nope.
Does the board have any questions of staff?
Is anybody, you said Pond Buddy's living there. You talked to anybody?
Have you spoke to the occupants?
In short, it's been re-inspected several times.
About how many times have you been out there?
I got 3 pages worth. 1, 2, 3, 4, 5, 6. Average maybe 14 times. I spoke with the owner, the tenant, who said his son, who also lives there, was displaced or divorced. That's why everything was in the back. I spoke with the owner, who is in Key West, who assured me over these months it would be clean. The process started, and then there was more junk.
So it's a
But I
landlord.
had contact with the tenant's son, and the owner. And here we are.
Mr. Crisco, when did this all start? How many months have you been working on this now?
Since January,
Since January?
yes.
Thank you.
I give him a 30-day extension. I did this and did that, but it didn't work.
Does the code speak to whether things are in the front or the back? Are there different requirements based on the location?
Junk and debris on the property, if it's viewable to the code enforcement officer, he can identify that that's a violation on the property.
And so hypothetically, if they had an 8-foot privacy fence, that's not viewable to the officer? Or are they allowed to peek over, take photos? I mean,
Well, there's no fence here, and the complainant who lives east of the property next door gave me permission to go on her property to take these pictures.
okay.
But just because it's covered up, it doesn't mean it's not in violation. You still are not supposed to have junk and debris, because say a hurricane comes through, it's not gonna say it's the stuff in the front yard or the backyard. It becomes projectiles regardless.
And Dr. Beckles is correct. But to answer your question, anytime that there's a privacy fence, code officers are not allowed to put a bucket down to climb up to look over. We can only observe it from a place that we actually have a right to be, and in this case would be the neighbor's yard.
Actually, that's been in practice in the past, over the years, where the officer, if he has permission from a complainant or adjoining property, that they can go inside that yard and take pictures and basically do almost anything that they want, as long as they have permission to be on that property.
Any further questions? Okay. Who wants to make a motion?
I've received a suggestion from the Code Enforcement Department that I'd like to pass on to you. The board has the ability to determine the period of time for the order to correct. Because of the number of months that have passed, trying to work with the owner, the Code Enforcement Department requests 10 days for the order to correct the finding of, if you do in fact make a finding of fact that this is a violation of the code.
Although this looks like much more than a 10-day job to clean that up.
It's within this board's right to discuss that matter, and it's also something to consider that the fine you will set next month would start as of the date of your order to correct, if next month it is in continuing violation.
I'm sorry, say that
It
again.
may
ma'am?
be more than a 10-day job to clean it up.
But that's not our concern. That's not our concern. Yeah, that's not our concern. So whether they have 10 days or more, that's our concern of whether we're going to do it 10 days as requested by the code officer or what. That's what you want to do.
Did you need clarification, sir?
Yes.
Okay,
Could you repeat what you just
Sure.
said?
I said that I'm passing on a request from the Code Enforcement Department that you make a motion that this owner only has 10 days in his order to correct.
Okay.
Because the amount of time that has passed already in this case since January, trying to work with the owner, trying to find compliance has not been achieved. And there has been regular communication with the owner and resident there. And based on non-compliance, they have requested and suggested that you set a time frame of 10 days. It's up to you to decide how long you want to set, and it's for you all to discuss.
Okay.
Because code enforcement's already been out there 14, 15 times.
Well,
That's
does
why-
that clearly document
Right.
that he's been out there 14 times?
Yes, because he was reading from his record of his inspections,
Right.
which is available to the public to view on CitizenServe when the code enforcement officer goes out and inspects, and that's how the cost recovery statement was generated based on the number of inspections that the city has had to do.
But
But
those,
it's
a
worth
lot of those
keeping
were
in mind.
courtesy visits because he didn't have an obligation to go out that many times. I mean, if he went out once or twice,
Is it really a courtesy if they pay for it?
but it doesn't reflect 14 times on they're not charging him for 14 times.
Yeah, there's 9. There's 9 on the cost recovery statement. And it might as well be worthwhile to know that the landlord is going to be liable for the fine, not the tenant. I mean, obviously he can step in, but the tenant has created the disaster that will have to be cleaned up, not the landlord.
But we're just trying to determine if they're in violation or not.
Well, they are in violation.
That's where you need to make your motion on the violation.
Okay, I'll do it. Does anyone have any objections to the 10-day?
No.
Okay. I'll do it. Yeah, I'll do it.
Go ahead, sir.
I move that the board issue the following findings of fact in case number 18-72 relating to the defendant Daniel Gregory Barron. Defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 206 Willow Street, Titusville, Florida. The defendant is in violation of the following provisions of the Code of Ordinance for the City of Titusville, Section 12-23, junk and debris.
Second.
Motion by RL, second by Gina. Any questions? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its order to correct relating to the defendant Daniel Gregory Barron, adjudging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the finding of facts, giving the defendant until 9 a.m., if I'm reading this correctly, on May 24th. Is that right?
Yes.
Okay. To correct the violation to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on June 11th? Are we going to do that?
Yes.
Okay. June 11th, 2018, to show cause why the violation has not been corrected and why this board should not proceed to impose a fine for the violations. The defendant is ordered to pay $463.71, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second.
Motion by RL, second by Ed. Any discussion? Roll call vote, please.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Vice Chairman
Yes.
Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes. Motion carried. All right. Next one, please.
For case number 18-73, the property located at 4105 Hood Avenue, the city wishes to continue this case for 1 month to allow the property owner additional time to correct.
Need a so moved on that?
No.
So moved?
Second.
A motion by Ed, second by Joe. Any discussion? Roll call vote, please.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Chairman Bell?
Yes. Motion carried. So they have 1 month. Okay. All righty.
The next case on your agenda is number 18-74 for the property located at 560 Hanover Drive. I have Officer Crisco here to provide testimony regarding the nature of this case. There are 2 violations that are listed on your agenda. Officer Crisco has indicated to me that the second listed regarding the fence has been withdrawn as of February 28th, 2018. The fence was removed. Violation number 1 is specific to a roof, not a fence. So the permit required violation, we'll get into the details of that, is specific to a roof and not a fence, and we're striking line number 2 in your agenda. Officer Crisco, did you have an opportunity to inspect the premises at 560 Hanover Drive?
Yes, I did on February 7th, 2018.
Did you find this property in violation of the Titusville Code of Ordinances?
Yes.
What was the nature of the violation?
Section 656, permit required roof.
Did you provide notice of the violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
Okay, please submit the notice of violation into evidence as exhibit number 1. Careful. After your initial inspection, did you re-inspect the premises to determine if the property was in compliance with the violations as cited?
Yes, I did 228.
And at any of your inspections, did you take photographs of the property to elaborate on the nature of the violation here?
Yes, I did.
Let's start with the
Yeah,
February 7th.
2/7 is that's the, on 2/7, this house originally went there a month before on a water complaint, and I found several violations which were corrected, other than the roof. As you can see, it's covered with a tarp, and it necessitated a new roof. That was taken February 7th.
Okay, next photo, please.
When I did some research, when I went back the second time on February 28th, there was a sign in the front, Bookart Roofing Company.
What was the date of this photo?
That was 2/28 on my second time I went back.
And did you close out the fence visit?
Yes, on
violation
that day.
visit?
Yes,
Okay.
I'm sorry.
Exhibit number,
Where they took
photograph
that?
number 2?
No, I think he just made a mistake.
Well, nothing was mentioned.
And this one is
So we
the
got two.
new roof that was complete. On 3/20, I think I took that picture. And as of 10 minutes ago, I checked our computer to see if there, because I did talk with the owner, and when I posted on Code Board on April 30th, and he told me he was going to contact the contractor to get a permit. And as of 10 minutes ago, there was none.
Still no permit?
Still no permit.
I have a question,
Yes, sir.
perhaps I missed it. There is other violations here. You didn't mention anything about those.
I see that those are listed there also, and I saw that as right before I submitted it to you, and those were not included on the agenda. I'm
No,
not
they're
sure
not.
if they were not included on the supplemental notice to the owner, but they are not under consideration for you to assess with the owner those additional violations, because they're
Okay.
not noticed on the hearing and complaint.
Is it not standard practice for the contractor to pull the permit?
It is.
So, how much time are you prepared to allot the guy to look into Bookart Roofing?
I'm sorry, can you repeat the question?
Bookart is who we're assuming completed the roof, and so most likely they would have been up to them
Who
to
they? I'm sorry,
It was
are
up
you
to
talking
Book-
about the owner or the city?
the owner. It should have taken, the owner will need to contact Bookart Roofing and find out why they didn't pull a
Should
permit to
have.
do their job.
Correct.
So,
That was the conversation the city had with the owner.
okay, but my question to you guys is how long are you prepared to give them to find the answer to that question?
But that's not our responsibility. We're supposed to say was a permit issued or not. It's not
Correct.
for us to assume stuff about the owner and their relationship with the contractor and all of that. Our question is just, are they in violation or not?
Absolutely, that's our question right now, but if this comes back for a continued violation, I absolutely want to know what kind of liability they've set themselves up for. That's why
But
we're a
that's not-
public panel, we can actually relate to the public.
The liability of the owner having an unlicensed contractor.
Yes.
Is that
But
what
our
you're saying?
Or
question
No,
really
wait,
is-
can we not?
Bookart is licensed.
Yeah, well, it's on his sign, so supposedly he is licensed, so. The owner needs to ask him why he didn't pull the permit, bottom line. Go ahead, Mr. Thomason, you have something? Glenn, you have something? You had your hand up. Okay. So right now, we're just figuring out why they, we just,
That's not
our
our
motion
question.
is
Why
on
it's not
whether or
our
not they
issue.
had the permit or not, yes or no?
All right. If I may proceed with the additional documentation, I would like to ask Officer Crisco, based on your inspections, did you file a complaint?
Yes,
And did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class and certified mail posting the same on the property and at City Hall?
yes, I did.
And do you have an affidavit as to this notice?
Yes,
Please submit the affidavit of notice of hearing and complaint to the board as exhibit number 3. And as of today's inspection, you verified that there is no building permit on file for the work that was performed. Is that correct?
that's correct.
And do you have a cost recovery statement detailing the cost incurred in bringing this case before the board?
Yes,
And what is the amount?
$393.27.
Please submit the cost recovery statement into evidence as exhibit number 4. this point, the city requests to make a finding of fact that there is in fact no permit on file for the roof that was done if the evidence that has been presented meets your satisfaction. Does the board have any questions for staff? Thank you, Officer Crisco. Regarding the time frame, Ms. Edens, the only thing I can comment is that the work was done without a permit, and if a permit was applied for, that would be a different situation. There has been no application that I have found on this property for the roof work that was done sometime in February or March of this year. The initial inspection was in the beginning of February, and by March 20th, you see that the roof was complete. I don't know exactly when the work was done, but here we are, May 13th, and the notices were given to the owner of record that they don't have a permit for the work that they hired someone to do. Regardless of who did the work, regardless of who put the sign in the yard, I think that the evidence shows the work was done, and there is no permit on file with the city as was required by city code.
What do you want to do?
I don't mind finding a fact, but I would like to reserve costs just till we can see how it
Well, you put that
plays
in your,
out.
do your finding fact and put that at the bottom of the thing.
Is everybody on board with that?
You're making the motion.
Who's making the motion?
Why?
Who's making the
Because I just feel like if I hired somebody to do my roof, I would assume they pulled my permit. And so after the fact, I would go like, oh my God, why didn't I have a permit? And yes, I mean, it's on you to now dig that up, but I think that this person could be completely innocent in this whole process and not knowing that a permit was there. And I'd like to reserve costs if the roofing company comes back and says it's our mistake and makes it right for them.
But when was the first time they were notified about this? It was what, February? And it's like May, and
7th.
nobody's responded or no one's even questioned or anything?
Do we know that? And they could be in the process of communicating with the roofing company. If they made an error, they may not be.
That's not our concern.
I agree with Ashley about that, but there is a
They're not
violation
here,
here.
they haven't called, have they called code enforcement? Have they called building?
Officer Crisco, can you come back up to the podium, please? I can say that, as Officer Crisco mentioned, he was out there on a prior case prior to, one of the reasons so many violations were in the notice of violation is because there's other things going on. That's okay. Have you had any conversations with the owner at this property regarding the roof permit?
On posting of code board, yes.
When you posted regarding this
That was
hearing?
on April 30th.
Okay.
Let me just pull it up on here, just to make sure.
Is the owner living there?
No, he's rehabbing the house to rent it out.
Okay, that's why it looks so different.
Actually, let's see, there was no major construction on February 28th, and that's when I talked with the owner originally, and he said that the new roof, I told him the roof was put on without a permit, and he said he would call the contractor, and that was on February 28th. And then when I went back on posting for code board on April 30th, I reminded him again that there was no permit on file, and he said he would call the contractor and have him apply for the permit. So on 2 occasions.
It's been 6 weeks.
Okay.
And the roof was put on in
Sometime
February.
between the 7th and the 28th.
There was a previous case, like I mentioned, I should have printed it out. I originally went out there the month before on a water case. The water was disconnected. And because it was vacant, I closed the water case, but there was other violations which were corrected, and which led to this here one on February 28th. But, oh, wait a minute. It takes a while before it sinks in. There was when I went out there originally on the water case, it was a previous owner. On February 28th, we found out there was a new owner, so that's why we had to recite on the permit.
And the roof was completed pre or post February 28th?
No, previously, forget all that. That was when I went there on the water bill, and we had to recite on February 28th because the new owner took possession.
But the roof was done on the 28th, or it was done after?
It's been done, the process was being done. It wasn't complete. on
No,
that day.
she's asking you, when was the new roof applied? What date was?
Well,
did you
whatever
notice the
date
new-
that looked like that in March?
March 20th is the day we know that it was
Yeah,
completed by.
that's the one that looks new.
It was not completed on his
No.
visit at February 28th.
No,
Okay,
not at all.
sometime between that time.
Right.
That answer?
Whatever you want to do.
Thank you.
I'll make a motion. You ready? I move that the board issue the following findings of fact in case number 18-74 relating to the defendant Mel's EQ LLC. The defendant was properly notified of the violation as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 560 Hanover Drive, Titusville, Florida 32780. The defendant is in violation of the following provisions of the Code of Ordinances of the City of Titusville, Section 6-56, by reason of a roof being put on without a permit.
Second.
Motion by Ed, second by Ed. Motion by Gina, second by Ed. Any discussion? Roll call vote, please.
Member Richardson?
Yes.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Chairman Bell?
Yes. Motion carried. Next motion, please.
I move that the board issue its order to correct relating to the defendant Mel's EQ LLC, adjudging the defendant to be in violation of the section of the Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9 a.m. on June 8th to correct the violations to the written satisfaction of the code enforcement officer or to appear before this board at City Hall, Titusville, Florida on June 11, 2018 to show cause why the violation has not been corrected and why this board should not proceed to impose a fine for the violations. The defendant is ordered to pay $393.27, which represents the cost incurred by the City of Titusville to bring this case before the board.
Second.
Motion by Gina, second by Ed. Any discussion?
So I just say no in the roll call vote for the
Want to?
costs?
Yep.
Okay.
Roll call vote, please.
Member Edens?
No.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Chairman Bell?
Yes. Motion carried. Next case, please. Chelsea.
Next, we have case number 18-75 for the property located at tax ID number 2209177, Brittany Way, Titusville. The city wishes to withdraw this case due to compliance. It was achieved on May 9th, for your records. Next, last case for the afternoon is number 18-79. Officer Crisco again is here for the property located at 5140 Sander Drive. Officer Crisco, did you have an opportunity to inspect the premises at 5140 Sander Drive?
Yes, I did.
And when was your initial inspection?
Wait a minute. Make sure I get the date right. June 26, 2017.
Okay. And did you find this property in violation of the Titusville Code of Ordinances?
Yes, I did.
What was the nature of the violation?
Section 1223, junk and debris, and Section 1326, overgrowth.
Did you provide a notice of the violation to the owner of record by first class and certified mail, as well as posting the same on the property and at City Hall?
Yes.
Do you have the proof of mailing and an affidavit attesting to this notice?
Yes.
Please submit into evidence as exhibit number 1. Did you take photographs of the property?
This morning I did.
Let's see what they look like. I think you have to zoom out.
It's 5140 Sandra, as you know, that's the front of the property.
Imperial State.
Okay, when was this photograph taken? Sorry.
This was this morning.
Okay. May 13th, first.
Oh, no, wait a minute, is that, wait a minute. That's hard to say. Yeah, I'm sorry, I got one that was taken earlier, I'm sorry.
Today. This is the only one
Yeah,
for today?
that's today, and this is today, but I'll show you the junk and debris. The camera didn't, it was raining this morning. So this was taken last year.
Do you have any others from today first?
Holy moly.
Well, yeah, I do, but
we see the house?
we're going over the sequence here, but.
Well.
All right,
is
that's
also
this morning also. That's the overgrowth in the back, which is almost roof high.
So there's two full-size photographs that were taken today for the record.
And the one I took of the shed this morning, I guess the camera didn't go through the raindrops, so I had to pull this one out of the computer. And it shows the shed in the back, the junk and debris, which I consider junk and debris falling over.
What was the date of this photograph?
On November 21st, 2017.
Okay, so this is from 2017 after the case was started. Can you describe what's in this photograph, Officer Crisco?
That's the front yard.
What are you
That's the house.
showing us as far as the violations?
Oh, the front part, I'm sorry. The neighbor next door is cutting the front, but he doesn't have the proper equipment to go in the back. That's why that
The front yard
looks
is
like.
maintained, and that's part of what you're showing the board.
Exactly.
Okay.
And the house is not occupied?
No, both parties are deceased, but it gets better. I talked with the son. On April 17th, he has no interest in the property.
Jeez, Luigi. Oh, sorry. Did I do that?
Just a catch.
So based upon your inspections, did you file a complaint?
Yes,
Did you issue a copy of the complaint and a notice of this hearing to the owner of record by first-class certified mail and posting the same on the property and at City Hall?
yes, I did.
Do you have an affidavit that adds to this notice?
Yes.
Please submit the affidavit into evidence as exhibit number 3.
Does the son live in town or out of town? Does the son live in town or out of town? The son.
It's a local number. No, it's 321 number.
But he's not the owner.
He's the only relative, right?
In what way do you see that we can achieve compliance in this case?
He doesn't,
Are you asking me?
oh, you? No.
The compliance could be achieved by having someone come to the property and clean up the shed that's fallen down in the backyard. I believe that was the case. Was this one that has a shed in the backyard? Is that part of
Yes,
the junk
it's-
and debris?
Yes.
Do you have a photograph that can show that to the board?
It's somewhere back on
It's
that way.
across, it's going across.
Where he cut it, he made it this morning through the raindrops.
You said the son has no interest in the property?
Well, the son, that's the only one. The mother and father are deceased.
Right,
And I
right.
finally made contact with the son through the water department, and he says, what do you want me to do?
Are there other children?
I have no clue.
I mean, the house looks
I have no
sound.
clue. I just got that
Because the
number from the
neighbor-
water department.
What knowledge do you have about the front yard being maintained? How do you know that? the front-
I've talked with the next door neighbor.
I mean, the structure looks sound. I can't understand why anybody would totally abandon
know.
this sound house like that.
So if we assume that there's no one that has an interest in this property, how do we achieve compliance?
The city needs to put the public on notice by recording a final judgment on the public records of Brevard County that this property is in need of correction because of the following violations, which this board has the ability to make finding of, and then any potential buyer of this property in the future would know that those are issues that need to be immediately corrected. That's what this board has the ability to do, is to create the fine based on the finding of fact of whether or not there's a violation as presented.
Okay.
But it still has to go through the whole shenanigans before.
I don't know whether someone will decide to enter into probate for this property. I don't know whether the property will be sold through some other means. I don't know what will happen with this property. If I had a crystal ball, I would share it with you.
Okay, one more question, and you may have to answer this one. Do we make a motion to have the city go in and clean up that backyard?
You can if you wish, but however, once that this happens and we get that process because of neighbors' complaints, we're going to have it done anyway.
Oh, okay.
Which we'll put it into compliance, but with that being said, we need action of this board to give us that finding of fact,
Okay.
just as we did in the one earlier.
Okay, so we do the finding of fact and then see what happens within the next month. And then if it comes back next month, which it probably will, then we do the next bout and then turn it over to Mr. Rogers to turn it over to the city council.
Correct.
Okay, and we can shorten that up real fast.
You can.
Like this month, next month, and then.
Actually, if y'all give a shorter date, I'll get it mowed to that date as opposed, because it's at a state now where we can't allow it to remain.
No, okay, all right. So we can shorten that date, 10 days or less?
10 days would be appropriate.
Okay. Does everybody understand that part? Okay. Any
Thank
questions?
you. I have one more document to give you before
Sorry.
you make any motions. I'm sorry for leaving one off. We've got a cost recovery statement detailing the cost incurred in bringing this case before the board. Bob, what is the amount?
$569.37.
Please submit the cost recovery statement into evidence as exhibit number 4.
Do you know how long it's been vacant, Bob, or how long they've been gone?
Ever since,
The initial inspection by the Code Enforcement Department was June 2017 for this particular case.
Okay. And that was because of the water thing.
No, that's a different case, I think.
That was junk and debris.
Run it together.
I'll make a motion.
Okay.
All the way through? Yep. I move that the board issue the following findings of fact in case number 18-79 relating to the defendant Gerard E. Madigan and Joanna D. Madigan. The defendant was properly notified of the violations as alleged in the complaint. The defendant is the owner of or in possession of the real property located at 5140 Sandra Drive, Titusville, Florida.
Second.
The defendant is in violation of the following provisions of the Code of Ordinances of the City of Titusville. Section 12-23, junk and debris, and Section 13-26, overgrowth.
Now you still have seconds.
Now I second.
All right, we're gonna say. Motion by Ashley, second by Ariel. Any questions? Roll call vote, please.
Vice Chairman Beckles?
Yes.
Member Edens?
Yes.
Member Monis?
Yes.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Yes.
Chairman Bell?
Yes, motion carried. Next motion, Pete, please.
I move that the board issue its order to correct relating to the defendant Gerard E. Madigan and Joanna D. Madigan, adjudging the defendant to be in violation of the section of Code of Ordinances of the City of Titusville as determined in the findings of fact, giving the defendant until 9 a.m. on May the 24th, 2018, to correct the violations to the written satisfaction of the code enforcement officer, or to appear before this board at City Hall, Titusville, Florida, on June the 11th, 2018, to show cause why the violations have not been corrected and why this board should not proceed to impose a fine for the violations. The board reserves jurisdiction to determine the costs incurred by the City of Titusville.
Motion by Ashley, second by
Second.
Ariel. Any questions?
Is there a reason why you're withholding costs?
I just figure we'll wait till we get to the fine thing to determine whether or not we're gonna tax people even more or someone else even more.
The city has already incurred all these expenses going out there and all the stuff that's listed there, so
Well, by next meeting, we absolutely have the same right to tack that $536 on the fine that we impose. I mean, I didn't say that there's no fine and that's established. We still have to establish that
So you
next
reserved it
month.
till, all right. So it's been reserved till the next vote, or the next hearing. Any other questions? Roll call vote, please.
Member Grant?
Yes.
Member Monis?
Yes.
Member Ozon,
Yes.
Member Richardson,
Yes.
Member Edens,
Yes.
Vice Chairman Beckles,
No.
Chairman Bell.
Yes.
Motion carried. So we'll hear about probably next month. Okay, you want to talk to us about these cases not heard? They're all closed, ready to go? So we don't have anything to do them?
I have no comment to add except that the Code Enforcement Department included them for your reference as cases that were previously found in compliance, and no action is needed by this board.
Okay. Well, they've been busy because of inoperative vehicles. And a business tax. Okay, Board Attorney's report. He's not here. City Attorney's report.
Your board attorney is here, or not here right now, and in, the decision of whether or not to steal his thunder, I wanted to inform this board that he's submitted a formal document to the city of Titusville through my office, informing us that he plans to retire and discontinue serving as the board attorney, and that information was shared with the city council, and the city council the city will be looking for a new attorney to represent this board that would be effective after, of course, with the board attorney will be here through August 1st of this year. So we don't have that much time. We have a lot of work to do to set out a request for proposals and interview and figure out who's going to fill his shoes. It's not going to be an easy job to.
Well, he's been, 32 years, 35 years?
I think it's 32 years, yeah.
When he's retiring.
Is he also voluntary, or does he have a paid position?
Oh, no, he's paid.
He's paid for.
No, he sent a copy, we got a copy of the letter too. So, yeah, we knew that.
And I have to say that I met with him a couple of days before he went on vacation, and he assured me that he'd stay longer than August 1st if we needed him to. And, well, I guess I'll wait till members report before I say anything further.
Okay. Anything else? Do you have anything else, Chelsea? No. Okay. Mr. Lynn? None? I don't have a report. Other than, yes, Mr. Rogers is retiring after 30-some odd years doing this business. And it did come up at the city council meeting, the first part of the second meeting in April? First day of April?
April the 24th.
Okay, the second meeting in April. So that's the reason we're going to look for, that's the reason city attorney's office has to look for a new attorney. Any questions about it, board members? You got something you want to say, Mr. Joe?
I always have something to say.
All right,
Yeah, if I can do it now.
go ahead.
But he did assure me that if he needs to stay on after August the 1st, he'll stay on. And having thought about it, I would make a motion that this board asks the city council to consider a committee made up of a representative from the city attorney's office, Attorney Rogers, or anybody that he should designate, like former city attorney Dwight Severs, and a representative of this board, preferably the chairman or vice chairman, to interview the people to consider as board attorney and present that person to the city council.
Can we do that, Chelsea? Can we make that a motion? I don't know.
That we send that recommendation to the city council, a letter making that recommendation to the city council.
I don't know if I can give you the appropriate answer, but my gut instinct is that I don't know whether it's appropriate to have a board member on the committee. It may be okay, but I don't know if I can give you that answer. You can make the motion. I just don't know that I can promise you that that's going to be followed through.
I made the motion because he represents this board.
I understand, but I don't know if that's
I don't know
a
what the protocol
conflict
is.
that is
Well, let's
permissible by the city.
Go ahead and make the motion. Because he's our attorney. He
Right.
doesn't work for the city
Okay.
attorney's office.
We understand that part, and I got that. All right, now go back and tell me what you want on your motion so I can write it down.
That we recommend to city council that they consider establishing a committee made up of a person from the city attorney's office, Mr. Rogers or his designee, which might be Dwight Sievers, and either the chairperson or the vice chair is a committee to interview the attorneys to represent the board and make a recommendation to city council. It's up to them if they adopt that or not. But it's sending a letter to city council of our recommendation.
No. I'm sorry, I don't agree with you on it. It's not our position to interview any prospective attorney that's going to represent us. The attorney is paid by the city of Titusville, not by the Code Enforcement Board. Therefore, the city of Titusville, it is their job to determine if the attorney that we are going to have representing us has the credentials necessary by the city of Titusville, not by the city, not by the Code Enforcement Board.
I think that exceeds our mandate as well. I don't think we.
I just don't see
really
that.
have that. I wish we did, but we don't.
It would be nice if we could, but it's not.
If the city attorney themselves or someone from that office makes a recommendation to council, are they not in conflict of the Sunshine Law? They're kind of in conflict because they're picking the board's attorney, and sometimes the board's attorney is in conflict with the city attorney. That's what I'm saying.
All right, let's do it this way. Before a formal motion is made, before a vote's taken on it, can we check into this even with Mr. Rogers and with your office? Absolutely. I feel better doing that and then see what comes out of that.
So you want to table his motion until
we get further instructions.
And we have really nothing
further information.
No one to compare it on. Mr. Rogers has been here forever, so we have no have no way to say that someone else would be biased towards the city.
I know he's talked to several real estate attorneys in town, and nobody seems to want it right now.
I agree with you. Table
So
this motion.
let's find out what we can and cannot do.
Right.
And what information we can get. Is that all right? Think that's applicable at this point?
I go for it, as long as it's tabled and it's on the agenda for the next meeting.
Okay. All right, Chelsea.
Could we get a motion that you vote on tabling, a vote on the idea of tabling the motion to the next meeting so it's clear for the agenda what exactly you want?
So moved.
Second?
Roll call vote, please.
Or discussion first? Roll call vote?
Moniz? Member Moniz?
I'm sorry.
Yeah.
Member Ozon?
No, hold on a second. I didn't vote. No.
We're voting on the table the motion. We're voting on the table of the motion.
Stands no.
Okay.
I stand with my.
Member Ozon?
Yes.
Member Richardson?
Yes.
Member Grant?
Reluctantly, yes.
Vice Chairman Beckles?
Yes.
Member Edens?
Yes.
Chairman Bell?
Yes. All right, so motion carried. We'll get the information, make it applicable if possible, and then make a motion to provide information to the city council.
Okay.
If we could, Member Richardson, if you could get with me after this to write down so it goes how you want it written.
Absolutely.
Get the exact wording, yes. Okay, anything else? All right, we're adjourned.
I had. Held down on US 1, and nothing has been said about that, and I still see in
Across from
talks.
McDonald's.
on the roof, across from McDonald's?
Yeah, they have active permits on there. It's, if they don't, you'll probably see them soon.
Okay, no, I was, you know,
I have to wait
it
till
hasn't
the-
been in the
they
limelight
expire.
in a while, and it was
Yes,
here all the time,
no, we-
and nothing's been said about it.
Yes, sir.
I happened to drive by
again-
there the other day, and I go, gee, it's still
And-
got
and-
tops on the roof, and
Well-
we haven't heard anything from it. Thank you.
I don't know. It sounds like.
Yeah, they got lots of tarps on
Banging.
their roofs.
All right. Meeting adjourned.